Good afternoon, and welcome to AIADA's AutoTalk. I'm your host, Rachel Soleimani. Before I introduce today's presenters, a few quick reminders as always. Everyone that has registered for today's program will receive a copy by the end of this week. And if you have any questions, feel free to enter them into the lower right side of your interface under the Q&A bar. Our presenters will try their best to get to them all. Joining us today are Travis Vance and Carl Lindgren, partners at Fisher & Phillips, LLP. They have a lot of important information to share with you, so I will let them have the mic. Take it away, guys.
Okay, well, good afternoon, everybody. This is Travis Vance with Fisher & Phillips. I'm in the Charlotte office of the firm, and my colleague Carl Lindgren is also on the line, and we're glad to be here with you this afternoon to walk you through sort of the legal aspects of a very uncertain time. Carl will be weighing in throughout the webinar, but I just wanted to give you a little background as far as our firm with respect to the COVID-19 pandemic. We had a inside or in-house council conference back at the end of February, which is sort of the last time we had anything in person, I would imagine. We had about 65 people in attendance, and that was just when the coronavirus was really starting to make news. The stock market had just crashed, and people were wondering about it, even though we were not yet in a pandemic. So we asked everybody, would you like for us to have an emergency session tomorrow to hear about this coronavirus? And so everybody in the room's hand went up. So that meant that me, yours truly, the only workplace safety attorney in the room, had to stay up most of the night to get ready for this coronavirus presentation. So I gave the presentation the next morning. And since then, that was on February the 26th or the 27th. Since then, I've talked to over 500 different companies about COVID-19. And have done about 45 to 50 webinars, and certainly have heard a little bit of everything. It's been one of the most challenging but rewarding parts of my career, and I'm certainly glad to share that information with you and that knowledge. And if you have any questions, you can always email me and Carl during the presentation, and we're also going to have a time at the end of today's webinar where you can ask us questions. So let's go ahead and get started. I wanted to start off with sort of why are we doing this in the first place? Why is it important to listen to a webinar on COVID-19? Why is it important to understand what the issues are? Why is it important to train your supervisors and your employees on issues concerning the coronavirus? So throughout this time, this pandemic, it's sort of still a developing situation, but we're really seeing three different buckets of claims that you guys could face at your dealerships. The first one is sort of the OSHA bucket, and that's if you have an employee that feels like you're not following social distancing at the dealership, you're not cleaning and sanitizing the facility, they feel like it's an unsafe place to work, they're going to call OSHA or email OSHA and lodge an OSHA complaint. And then OSHA is going to do one of two things. They could send you a letter, what they call a rapid response investigation, and say, hey, we've got an unidentified anonymous employee who says that it's not a safe work environment because of COVID-19. How do you respond to that? And then you just write a letter back to OSHA explaining what your programs are. Or what they could do is what they call a remote inspection, which looks a lot like a rapid response investigation on its face, but there's key differences. They're going to be asking for documents from you, as well as asking for interviews of your hourly workers and your managers at the dealership. And they can also issue citations against the company as well. So there's a big difference there. Just make sure you carefully read those documents if you get them from OSHA. And then the last part of the OSHA bucket is the whistleblower aspect. And that's where you have an employee who's disgruntled. Maybe you take an adverse employment action, let them go because they didn't want to come to work. And we'll talk about that later on. Then they can bring a whistleblower claim against your company. And that's sort of the last piece of the OSHA bucket. And how you defend all those claims. You have a written exposure control plan for COVID-19 issues. You have trained your supervisors. You have trained your employees, and you're implementing all those programs in your workplace. The second bucket is the workers' compensation. It's been really fascinating to see how this has developed. But a lot of states, Kentucky and Illinois, to name a few, were a couple of the first. They essentially said if you work in a certain industry and develop COVID-19, then it's going to be presumed to be work-related, which puts the burden on the employer to show, in fact, it wasn't work-related. But if you don't have a written COVID-19 exposure control plan, you don't have any procedures, you don't have any training in place, it might be difficult to overcome that burden against your company. And then the last bucket is general liability, which relates a little bit to workers' comp, because what we're seeing is very creative, crafty plaintiffs' lawyers where they have an employee who has passed away or has been seriously ill because of COVID-19. They are not only seeking workers' comp from the company, but they're also alleging claims like intentional infliction of emotional distress or willful conduct or intentional misrepresentation or negligent misrepresentation to try to get funds from the company, not only from workers' comp, but also out of the company's pockets. So we're seeing that in addition to claims by employees, you're also seeing claims by third parties. And one of the most popular right now is that you have a spouse of an employee who works, at the dealership. The employee comes home and gives COVID-19 to the spouse and the children, and then the spouse files a claim against the company saying that there was some sort of public nuisance created by the company because they were not following CDC guidelines and not following OSHA guidelines, and they're suing the company that way. So plaintiffs' lawyers are getting very crafty with respect to the claims that they are filing with respect to workplace safety at this time. So what we want to do today with this webinar is arm you guys with tools and information that you can use to hopefully prohibit those claims or prevent those claims from being filed. And then if they are filed, you can successfully defend them.
Hey, Travis.
Go ahead, Carl.
Yeah, just real quickly, too, a couple other things that we're seeing that make this even more important or underscore the importance. We're also starting to see, and I've got 3 of them now, investigations by the Equal Employment Opportunity Commission related to the ADA, where people are challenging wearing masks or not wanting to wear masks or aren't being allowed time off and that kind of thing. So you can have your employees coming at you from a more traditional angle, but with respect to that. And Travis, you may have seen some of these too. We've actually had a few customers who came down with COVID and were then looking to blame the dealership and asking, well, which employees touched my car? And I want to know what protocol. So that, I think, underscores too where you were headed, Travis. Sorry to interrupt you.
With those third-party claims, certainly with the third-party claims, you have the customers and the visitors to the site who say they got COVID-19 from your workplace, and they're not barred by workers' comp, so they could sue you. In a lot of places, there's no cap for that. One of the other interesting things we're seeing from a workplace safety standpoint is if you're in a state or location that requires the use of masks, and you're not requiring your customers when they're at the dealership to wear masks, then OSHA's claiming jurisdiction there and saying that by not requiring your customers to wear masks, you're creating a workplace hazard to your employees. And we specifically have seen that in the Pacific Northwest and Nevada are 2 places where that's occurring. So that's another thing to keep in mind. With respect to some of the procedures you can have in place to prevent all these claims, this is actually my favorite slide of the whole presentation, and I moved it way up so you guys can really pay attention to this one because this is my favorite part of having dealt with all these confirmed cases throughout the pandemic. And that's if we have an employee who has COVID-19, what are the steps that we need to do to follow and to make sure that we're keeping a safe workplace? So I'm going to pick on this person. There's always a sick individual, COVID-19, person who has COVID-19. And that person is Johnny. So Johnny, the employee, has COVID-19. So we're going to send Johnny home, and Johnny is going to be go into a physician, and he's going to be cared for by the physician and stay at home until he's released by the physician or until he is eligible to return under CDC guidelines. And we'll talk about those later. After Johnny leaves, we're going to call him, and we're going to ask Johnny who worked near you, who worked closely with you for the 48 hours before you had symptoms. And what we're looking for are the employees that our firm actually created this numerical acronym out of the CDC guidance. It's the 6-15-48 employees. And those are the employees that worked within 6 feet of Johnny for 15 minutes or more for the time period of 48 hours before Johnny had symptoms until Johnny is released to come back to work. So if you have employees that meet the 6/15/48 criteria, those employees need to do one of two different things. If you're following CDC's general business guidance, which would apply for almost all dealerships, then the 6/15/48 employees need to be quarantined for 14 days. And one of the most popular questions we get, I know it's coming, is what if the employee goes that's been exposed 6/15/48, and on day 3 he gets a test and he's negative. Well, you can't cut short the 14-day incubation period. The virus may not be set up in your body for 10 to 12 days. You get a negative test on day 3, day 5, day 8. It could still develop in your body. You can't cut short the 14-day quarantine period with a negative test. You can only cut it short with a positive test, which is like you're crazy. But here's how that works. So let's say that employee is exposed to Johnny on day 1, and then on day 3, he goes and gets a test, and he is in fact positive. Well, under the CDC guidance, that employee only has to be out for 10 days since he had symptoms or had the test, as long as he hasn't had a fever within 24 hours and his symptoms have improved. So technically, that employee could come back on day 13, which would be quicker than the employee who never got a test or tested negative. That's one of the biggest questions we get. It seems counterintuitive. The CDC has specifically addressed that, but there's a 14-day quarantine period for those that are exposed, and there's a 10-day self-isolation period for those who have tested positive for COVID-19. So that's very clear, very, very important to keep those things separate. So with respect to the 6/15/48 employees, you ask Johnny about them. You can also confirm it with video surveillance or sign-in sheets or other information you have to determine where people were. So you've got those figured out. You've got Johnny figured out. Then you're going to clean and disinfect your workplace. You're going to clean and disinfect where Johnny worked. You're also going to clean and disinfect where Johnny may have used common areas such as a bathroom or break room, buttons, doorknobs, frequently touched surfaces. You're going to make sure you're going to do that as soon as possible and follow the CDC guidelines for doing that, which are very clear as to how you should do that and what disinfectants you should use. And then the last thing to do is notify your employees. So we've got Johnny, we've got the 6/15/48 taken care of, but we're also going to notify the other employees who are not Johnny and not 6/15/48, but may have worked around Johnny. They may work on the same hallway, they may work in the same area, but they're not 6/15/48. The CDC guidelines say that you should notify those employees who may have been exposed to Johnny, and we believe that OSHA will claim that if you know about Johnny being COVID-19 positive and you don't tell those who might have been exposed, that could be a violation of what OSHA calls the general duty clause. So we think that you should notify those that work closely or around Johnny but were not 6/15/48. Okay, so those are the 4 principal things to do when Johnny gets COVID-19. We'll talk about a couple other things you'll need to do, but those are the 4 fundamental steps that you need to take. Just taking a step back for a second, as far as just a 30,000-foot view of either we're doing work right now or getting ready to go back to work, or maybe we're having more people at the dealership as opposed to working from home. It's a good time to designate a COVID-19 response team. Those are folks who are trained on your policies and procedures and know exactly what you're doing, knowing exactly what you're doing to fight the virus, what you're doing to implement social distancing. Make sure they're trained on how to communicate that to employees, because supervisors are just like any other professional that needs to have good bedside manners, whether it's a lawyer, a banker, accountant, physician. If they've got bad news or certain types of news to tell the employees, they need to do that, know how to do that appropriately. Because if an employee goes to a supervisor, they're scared and concerned, or the supervisor freaks out about it, that's not going to be good for morale amongst the workplace. Make sure you look at, reimagine everything that you're doing right now with respect to separating people, especially. We were talking about this before we jumped on the webinar. If you've been in any space with any other person during the pandemic, you realize how hard it is to stay 6 feet apart. Make sure you look at local and state shutdown orders. Do they require temperature taking? Do they require a mask? How are you going to comply with that? And then that written return to work plan. Very important. If you're in Virginia, and you're considered a medium risk or higher workplace, then you have to have one in writing as of a couple of weeks ago, because Virginia actually adopted a COVID-19 standard. If you're in other states, it's certainly a great idea, and the reason for that is if it's in writing, you can train your employees on it, you can communicate your policies to your employees, and certainly if it's not in writing, you can't do that. And going back to the first slide, if we're defending those claims, how are we going to show that we had a process in place? How are we going to show that we had procedures in place to a government agency or a plaintiff's attorney if there's a claim that's filed? Some other things to think about with respect to restarting at your facility, which includes just bringing more people back into the workplace. Do you have PPE? Do you have gloves? Do you have face masks? Do you have face coverings? Do you have goggles? What do you need in order to have people come back in? Are you going to screen your employees? Are you going to do it by taking their temperature? Are you going to do it by giving them a questionnaire? Are you going to use an app to have them fill out the questionnaire virtually? Are you going to have them do it in person? Do you have any employees that require transportation by carpool that you sponsor? Are there alternatives to that? We talked about training managers and supervisors. Signage is key. If you're going to take temperatures, if you're going to have screening requirements, you need to have signage at the front of the dealership that tells visitors, they may be subject to screening, they may have to wear a mask, whatever that might be. And then disinfecting. If you don't already have it in place, you should have the cleaning and disinfecting schedule for the dealership, especially commonly touched surfaces where the public may visit, waiting rooms. You should make sure that you increase that schedule. If it's 3 times a week, it should be 5 times a week, and so on. So now is the time to get that in place. And just from an OSHA standpoint, OSHA is the agency that's charged with keeping employees safe. So you just hear a lot about OSHA during this time. Personal protective equipment, that's PPE, that's the gloves and goggles and the face mask, and we'll talk more about that in a minute. But you should be training your employees on any PPE they have. You should be providing that PPE for free to your employees and making sure they're wearing it. If you have an employee who is going to be occupationally exposed to mucus or saliva, if they're taking somebody's temperature, then you have to have a bloodborne pathogen program. You have to have an exposure control plan. Your employees have to be trained on that as well. And then here's a very important one that's very common in any emergency situation, whether it's a hurricane or a fire or anything else. What we see a lot of companies doing is they are requiring employees to clean surfaces, clean vehicles, clean equipment out in the shop with disinfectants that they've never used before. And if you're using a chemical above household usage and grade, then OSHA's hazard communication standard kicks in. Then you have to train the employees on that chemical. You have to train the employees on what personal protective equipment they have to wear. You have to have the safety data sheets for all those chemicals. So that's a very common one that we see, that if you're using anything above household grade, then you have to have that hazard communication program. The infectious disease response plan is essentially that COVID-19 response plan that I mentioned earlier. Very important. Temperature taking, having a process in place. What are the 6 different factors that you have to consider when you're taking temperatures, and we'll go through those in just a few minutes. How are you going to comply with that? And then record keeping and reporting. It varies by state, but for OSHA, sometimes COVID-19 cases have to be put on your 300 log if you're required to keep 300 logs. In very rare situations, you actually have to pick up the phone and call OSHA. And we'll talk about that. It's very rare that COVID-19 cases will be reported to OSHA, but it's not out of the realm of possibility. And then for confirmed cases, we went over that 4-step process, and the last of which is you have to notify those employees who worked near Johnny, who may have been exposed to Johnny, so that we avoid a citation under OSHA's general duty clause. And that general duty clause is going to be used by OSHA anytime they don't have a standard like hazard communications or personal protective equipment directly on point. They can always resort to the general duty clause, and OSHA has already indicated that if you don't follow the CDC guidelines, they can cite you under the general duty clause. Of course, for the folks on the phone from Virginia, there's already a COVID-19 standard in place there that they can use. They don't even have to go to the general duty clause. We were hired to respond to that COVID-19 standard in Virginia. It was a very fascinating process, but it is in place at this point, and I would encourage you to take a look at that standard if you haven't already done so. Now, I mentioned OSHA record keeping. Most of you on the phone or that are familiar with record keeping, OSHA record keeping, you're familiar with what they call an OSHA 300 log. And that's very important because if you had someone in the shop who had, a contusion or, was out for a few days because they dropped something on their foot, maybe they rolled an ankle, something like that, you'd have to put it on your OSHA 300 log. Now, what we're going to talk about today is when do you have to put a COVID-19 case on your 300? Well, back in April, OSHA said that you only had to do an investigation to determine if COVID-19 was work-related if you were in three industries: healthcare, you were a detention center, or you were an emergency responder. But in May 19th, effective May 26th, OSHA said that you had to do an investigation as to work-relatedness if you were in any industry. So to the extent any of you on the phone keep 300 logs, then you are subject to this requirement. So as of May 26, 2020, if Johnny gets COVID-19, your employee, you need to ask Johnny, what do you think you got COVID-19? He may make it easy for you. He could say, I got it at my cousin's barbecue party. And then you just don't put it on your 300 log because it's not work-related. Then you ask Johnny, is there anything outside of work where you may have got it? Did you have some sort of birthday party or a service that you went to, or did you go to a wedding or something like that? Or did you go to the Sturgis bike rally, like one of the questions I got yesterday? Or do you think that it was at work that you got it? Did you work with a customer who had COVID-19? Are you up front and dealing with customers all day long, and therefore you might get it? And then you actually take a look at where Johnny works at the dealership and say, okay, was he around a customer who has symptoms? Was he around a coworker that had COVID-19? Once you've done those three steps of that process, then you have satisfied OSHA's work-related investigation requirements, and then you can determine whether you're going to record that on your 300 log or you're not going to record that in your 300 log. OSHA is not going to really care as much at the end of the day if Johnny's COVID-19 case is on the log versus not. But they're going to care about whether you did that investigation. So that's very important. The other thing I've mentioned is reporting requirements, which are different from recording. So recording is you put it on your 300 log. OSHA doesn't get a copy of that, but reporting is actually picking up the phone and calling OSHA and saying to them, we've had a COVID-19 situation, and essentially inviting them out to the dealership. And there's a lot of misunderstanding about this requirement, so I've got it kind of boiled down to 4 hypotheticals that I hope will make you understand when you have to call and when you don't. So Johnny is always going to be sick, right? So Johnny gets COVID-19, gets medical treatment above first aid, or he misses a few days because of the quarantine. But he doesn't go to the hospital. That's going to be on your 300 log, but you don't have to call OSHA. That's the typical COVID-19 case. But let's say Johnny has COVID-19 and then immediately goes to the hospital. We assume that all of these are work-related. So Johnny has work-related COVID-19, immediately goes to the hospital. He's admitted within 24 hours of leaving the workplace. OSHA requires you to report fatalities, inpatient hospitalizations, amputations, and losses of eyes. Okay, fatalities are 8 hours. The other 3 are 24. So here we have Johnny going to the hospital within 24 hours. He's admitted to the hospital, so we have to record that on the 300 log, and we have to pick up the phone and call OSHA because Johnny was admitted to the hospital, and it occurred within 24 hours of Johnny becoming sick. Now, if Johnny has COVID-19 and then goes home, and this is the most typical, this is very important. Johnny goes home, he's at home for a week, and then he gets really sick, and then he's hospitalized, okay? In that situation, you put it on your 300 log, but you do not call OSHA. And the reason for that is because Johnny's hospitalization occurred more than 24 hours from any work-related incidents. Okay, this is the number one misunderstanding about reporting OSHA cases to OSHA. If the hospitalization doesn't occur within 24 hours, then you do not have to report it to OSHA. Very important. Then the last one is if Johnny has COVID-19, he is hospitalized later than 24 hours after that point, but then he dies within 30 days of getting COVID-19 at work, then we have to call OSHA. So if he dies within 30 days, you call OSHA. If he's hospitalized within 24 hours, then you have to call OSHA. Okay? And one thing I will tell you, for those on the phone who do not keep OSHA 300 logs, if you had a situation where Johnny died within 30 days or was hospitalized within 24 hours, then you'd still have to call OSHA, even if you don't keep 300 logs, okay? Because the reporting requirements become separate and distinct from the recording requirements. That's very important to keep in mind as well. So taking temperatures, I just want to touch base on this because it's so important. Fortunately, a lot of municipalities have realized it's not not the best thing to take temperatures, because I can tell you I've handled hundreds of confirmed cases, and about 80 of them have been asymptomatic. So that makes you think maybe taking temperatures is not getting you anywhere, right? So when you're taking temperatures, there's really 6 or so things you need to consider. Our firm had a legal alert about it. We went over the 6 things about taking temperatures. The first one is, do you have to do it or not? Is it required by a state or local order? If you're not required to do it, I highly recommend do not put a thermometer in somebody's face or in their mouth or on their neck. It's not worth all the things you have to go through to train people to get them ready, because it's actually going to cause a greater hazard to those who are taking the temperatures, okay? So in lieu of taking temperatures, can you use a questionnaire that employees fill out before they go to work? Can you have them fill out a questionnaire when they get to work? Can you have someone stand behind a barrier or 6 feet away and ask them questions about their symptoms and what their temperature was when they took it before they came to work? Or if you really want to take their temperature, can you contract it out to a medical team? And another thing that I've seen work well is there's really good software. There's one called FLIR that I've seen, FLIR, where you stand more than 6 feet away, you walk in front of the webcam, and it will pick up your body heat so that somebody can read it, and there's no exposure, no PPE required. Then you have to think about this. Let's say you have 45 employees you need to get into the dealership by 8 a.m. How are you going to get them all in there before 8 a.m.? How are you going to keep that process private when you tell someone they have a temperature and they have to go home? Wage issues. You know, one of the things we're seeing, and we're going to see more of, especially in states like California, is that when an hourly worker gets out of the car and gets in line to get his temperature taken, there's going to be plaintiff's lawyers that say that as soon as he got out of the car and got in line, that's compensable time. So you better be prepared to pay that employee from the time he gets out of the car until he gets his temperature taken. And then if you screen your employees, then you probably need to screen your other guests, because that defeats the purpose of the exercise if you let other people onto the site without taking their temperature, if you're taking your employees' temperature. So a lot of different things to think about there with respect to taking temperatures. I like the FLIR webcam approach or the questionnaire approach, where they email it to you before they show up. And that way, if they're not going to pass the questionnaire, then they just simply don't show up. And that way, they're not exposing anyone to a hazard. Then I want to touch base, talk to you a little bit about face mask. There's a lot of confusion on, what's required and what should we do. Okay, so if you're requiring your employees to wear face masks, either by state or local order by policy, then you should do the things on the screen. And I'll kind of tell you how that fits into the grand scheme of things with respect to different types of face masks that we're seeing. So sort of on the far right end of the spectrum, you have the N95s. Those are the dust masks that you can get at Lowe's, but they are actually filtering the air. They're called filtering face pieces. Okay, so an N95 is a respirator. OSHA calls that a respirator. If you're requiring your employees to wear N95s or KN95s, if you're requiring them to do that, then you have to have a respiratory protection program under OSHA standards, which requires a fit test and a medical evaluation and a whole list of other things that you need to do. Which, frankly, if you don't have employees outside the pandemic wearing N95, you shouldn't put them in N95 just because of the pandemic. Okay, because it's not the safety aspect of it's not worth going through all of that and having that respiratory protection program. Now, keep in mind, even if your employees show up in a dust mask and N95 and they're wearing it on a voluntary basis, then there's still parts of the OSHA standard that kick in. You have to give them certain information if the employee is wearing the N95, even on a voluntary basis. So that's very important to remember. Now, most of you guys are going to be in the middle of the spectrum, the middle bucket, and that's going to be the face covering. That's going to be the cloth face coverings that are made. Everybody's got sort of their team on theirs. I'm a big Alabama football fan. I got my Alabama face covering. It's the face covering that looks like a face covering. It's the face mask, the surgical mask. Those fall into the middle bucket, and those OSHA says they're not personal protective equipment. With I tend to disagree with, because it does provide some protection to you, although most of the protection is to others. However, at our firm, we still think that you should treat them like PPE, because there's nothing but benefits that can come from that approach. And here's what I mean by that. That's following what's on the screen. This is OSHA's PPE standard. So basically, it just means you'll train your employees on wearing the mask, which will take about 15 minutes. You will do a hazard assessment of each task in your workplace, which is already required, but most employers don't do. And in that hazard assessment, you will note that the face coverings are required. It takes about 10 minutes. And then you also provide it to them at no cost and make sure that they, within reason, can get replacements so that there's no hazard to the employees. And the reason for that is because if you just allow people to come in with their own stuff, it's going to be dirty. It's not going to be protecting them. If you're providing it and you're paying for it, then you're keeping a safe workplace. And if there's ever an OSHA inspection, you'll be above and beyond, because you've done this hazard assessment, you've done training, you're providing it, you're making sure it's clean, you're making sure it's sanitary, you're making sure it's not posing a hazard. And there's just no reason, in my opinion, to not do this. It would take about 25 minutes, and you're going to be above and beyond in promoting safety at the same time. Now, on the far left, the last bucket, that's where you get the face coverings that are not the Alabama face covering. You're getting the face coverings that are bandanas and scarves and things like that, that are not actually meant to be face coverings. And really, those are not PPE. And with respect to your requirement as an employer, you just want to make sure they're not posing a hazard to the employees that wear them. Then I want to touch to you real briefly on social distancing. Social distancing, like Carl and I were talking about before the call, a lot easier said than done. If you've been in any workspace, if there's 2 people or 100, and no matter how big the facility is, it's hard to stay away from each other. So if you look on the screen in the top left, I've got an example of a break room there where you can use some painter tape, try to separate people as far as where they can sit while they're having lunch or taking a break. Just trying to separate them apart as best you can. Top right is a tabletop partition that we've seen in some large facilities to try to, if people want to eat inside, especially if it gets really hot, and then in the wintertime, they'll want to eat when it's in there when it's cold. So just trying to keep people separated the best we possibly can. And in the bottom right, you'll see the conference room set up, taking 2 chairs out, going from 6 to 4, having hand sanitizer on there. And the key is you should go through all your rooms, all your conference rooms, all your lunch rooms and break rooms, and labeling the occupancy in there. And it's interesting because I did a lot of research on this, and I came across an agency I'd never heard of before. It's part of the Department of Homeland Security. It's basically a fire protection agency, and they went through and they figured out that in order to keep social distancing 6 feet apart, you would need about 113 square feet per person in each room. So what you can do is you can go to your rooms and you can divide them by 113, the square footage by 113, and then you've got the safe level of occupancy. And the agency said that's a conservative estimate, but it's just something that I've seen from an agency that I thought was pretty interesting. In addition to these spatial considerations, think about non-spatial, like staggering shifts, staggering lunch breaks, how many people work in a particular location. You've got 2 shifts. You got the red team and the blue team. Maybe one team works Monday, Wednesday, Friday. The other works Tuesday, Thursday, Saturday. And then think about public areas like hallways or corridors, making them one-lane traffic so that you're not crossing each other going down the hallway, reducing the occupancy of restrooms and elevators to make sure people are not close to each other. So there's other things that you can do besides what you see there on the screen. A few other things that we commonly see issues on, and these respect to workplace safety, but waivers and acknowledgments. Back in March and April, the big thing is, I'll just get the employees to sign a waiver. That's one way to keep them from suing me. Well, that's a couple of issues with waivers. One, OSHA and most state courts and workers' comp commissions are not going to enforce them, so they're not going to get you anywhere legally. But they also don't look good from a public perception standpoint. There were some universities that got in trouble because they were trying to get football players, college football players, to sign waivers before they came back to football. And so they're not really going to get you anywhere, and it might be kind of embarrassing if it gets out to the public spotlight. So in lieu of that, what we've seen a lot of clients do is they have that written COVID-19 response plan in place, and it's basically like an employee handbook. You just have your policies in place, how people are going to be trained on it. And at the end, you get the employee to acknowledge they've received it. They will abide by the rules in that. They understand the risk of working during a pandemic, and then you just get them to sign off on it. It's a much softer landing than a waiver, and it certainly will be useful if you get any claim filed by the employee. So what if the employee won't come back to work? What if you have an employee that's just scared to come to work? How do you address that situation? Well, the good news is OSHA's threshold for not working, for refusal to work because of safety issues, is very high. It's so dangerous in the dealership that I'm afraid I might die today and I don't even have time to call OSHA. And you're certainly not going to see that in your locations, but you could see that in a medical facility if somebody was required to work on a COVID-19 patient without PPE. So the key is with these employees, just educate them. I can tell you, having dealing with over 500 different companies, you got to communicate to your employees what your policies and programs are. Make them feel comfortable. Take any worries that they have away, and that will hopefully keep them coming back. And then if they're just scared and won't show up and they don't have some sort of religious or medical accommodation that's required under the law, then you don't have to keep them on forever. But I will tell you, throughout this process, one thing that I've learned and I've seen that no matter what the law is, and as Carl can attest, this is, as far as the law goes, we're really dealing with a situation where we're kind of building the airplane while we're flying at the same time because there's just not a lot of law out there. But there's two things you should always keep in mind in every decision that you do. And one is employee relations. How's it going to fit with the employees, and how's it going to fit with the coworkers? And then in public perception, how is it going to fit with the public if you fire somebody who refused to come back to work or didn't pay them while they were in quarantine? Those are things you should think about as well. With respect to fitness for duty exams, if you have a DOT driver, you can certainly continue to do those fitness for duty exams. You can do COVID-19 tests. I will tell you a couple things with respect to COVID-19 tests. Make sure they're FDA approved. You certainly don't want to put your employees in harm's way. The other thing is, with respect to testing everybody for COVID-19, it falls into the category of be careful what you wish for. It's certainly not a bad thing from a health and safety standpoint. But we had a couple of clients, not dealerships, but other industries. One had 150 employees, tested them all for peace of mind. It had 91% positives. Only 5 of them had symptoms. And another client tested 200 employees. Only 5 had symptoms, and they had 100% positive. So what that means is that those employees are going to have to be out for 10 days. So how does that impact your workforce going forward? So those are just things to think about. One other thing to mention there is that antibody testing, the EEOC says you can't do that. That's an impermissible medical examination. So just keep that in mind. And then, maybe Carl, if you want to talk about the data privacy issues, especially in California, if you're taking temperatures or collecting biomedical information, you certainly want to make sure that they have the proper notices that are required in California and in other states.
Yeah, exactly. And we've got, I think there's a link that you can get some information for free on our website on that. But yeah, we've put together a whole packet, and I know a lot of our clients who are in California, the dealerships are pretty familiar with the privacy requirements that came in a year or so or 2 years ago with respect to notifying customers. But a lot of them at the outset didn't really realize that it would apply to the collection of information with respect to COVID. So another trap, and at least out here where I am in California, we're just seeing the plaintiffs' lawyers salivating at all of the places where you can stub your toe to come after you on that. So that's a real good point, Travis.
Yeah, and speaking of our website, Carl, just if you haven't been to our website, this is just somewhere, and it's a resource center. You can go there, you can get free forms, free information. There's FAQs on there about basically anything that we talked about today, plus everything you see on the screen. So if you haven't gone to the website, we encourage you to do that for free information, and then you can subscribe to the information that we send out with respect to legal alerts. And a couple of the things that I mentioned today were actually legal alerts. One was the six issues you should think about before taking temperatures, and then the other one was that four-part exam, four-part process for when Johnny has COVID-19. If anybody wants to email me, and Carl would be glad to send you a copy of that. In addition to that, a list of questions you can use if you have a COVID-19 case to determine if it was work-related under OSHA standards. And with that, I will turn it back over to Dan if Dan is on, or whoever might want to moderate the questions and answers.
Travis and Carl, thanks so much for speaking with us today. This information is so vital to keeping everyone safe and keeping businesses up and running. Thank you. Again, to those on the line, you'll be receiving a recording of this webinar by the end of this week. For more information about AIADA, visit aiada.org. Thanks for joining us and have a great day, everyone.